Margaret Senator O'Donnell.
I get Caherly, and I never enjoy, I have to say, Caherlack raising to disagree, even if just in a very, very small, modest way, with my colleague Senator Conway. Tánaiste de Farin of Fáilte Road Gajian and Chana the New. Tánaiste, you're very welcome, and I've actually found the contributions very insightful thus far from colleagues, and I agree with the vast bulk of the sentiment and the practicalities expressed in relation to this bill. But obviously, as you'll be aware, Minister, from previous discussions, our party does have some concerns which I don't think are insurmountable. And I think actually if we were to overcome them, it would actually greatly benefit and add to the legislation. So, Minister, I'll start by saying that Sinn Féin welcomes the opportunity to speak on this bill. We note recently that the Garda Inspectorate have raised problems with persons who have breached their bail conditions in the past during hearings with the Joint Oireachtas Committee on Justice. In that, Gardaí have to go and seek warrants to arrest them. This bill would amend that, and it is a welcome initiative. It is interesting that the Government have sought to listen to the Garda Inspectorate in this particular aspect of their complaint regarding bail, but not where the Inspectorate complained that there is virtually no monitoring of suspects while out on bail. It has got to the point where the Garda Inspectorate have said they doubt that Gardaí at many stations would even notice if a suspect failed to show up to sign in. We recognise that there are not insignificant levels of crime committed by people while on bail. However, it is important that we look at this in a rounded manner and not simply base justice policy on crude tabloid headlines. The fact is, suspects would be monitored while on bail more effectively if the Gardaí had the resources to do so, and colleagues have touched on the issue of resourcing already. And people, of course, would be less likely to be out on bail if their court cases were being held promptly. Also, that issue has been touched on as well. This is not just something that can be addressed by simply having more legislation that will inevitably lead to more incarceration, when it is fundamentally about resources that can be used more effectively. During the Dáil debates on this issue, there was extensive discussion around electronic monitoring and how it would operate. Electronic monitoring is not a substitute for evidence-based crime prevention measures. We are in favour of protecting the right to bail and the presumption of innocence within the legal system. We recognise that by virtue of the fact of the numbers within the Houses of Oireachtas, that it is likely that electronic monitoring will become a feature of our criminal justice procedures, and on that basis we will engage with the legislation and propose amendments in the Seanad at a later stage in an effort to make this a better bill. There was an attempt in the Dáil to remove the provision concerning the amendment of Section 6 of the Act of 1997, where a Garda is given the power to arrest a person without warrant if the Garda is of a view that a person is about to contravene a condition of their recognisance. Essentially, what is happening here is that the Gardaí are being given a very wide-ranging power to deal with crimes that have not yet been committed. It may be that the potential crime is not even going to happen, but as long as the Garda thinks it is, they are permitted to make an arrest. It should not be the case that powers of arrest are simply extended when there are no resources being put in place for bail supports and services. The particular provision is vague and needs to be addressed. To return to the issue of electronic tagging, we will table amendments that are based on the Council of Europe's 2014 recommendations on electronic monitoring. It is absolutely essential that safeguards are put in place that will protect data accrued from the use of tagging. It is also essential that where monitoring is happening, that it is carried out by a body on a not-for-profit basis. And Tánaiste, you'll know that just last week we passed legislation that sought to counter some of the very real dangerous issues that exist out there in terms of accruing data and how it is handled and subsequently possibly misused and abused. There are issues here regarding Article 8 of the European Convention on Human Rights and privacy provisions. This isn't some off-the-wall proposal. It is a reasonable and necessary and proportionate given the tech-based world in which we now exist, and we all acknowledge that danger. The Minister's response to these arguments in the Dáil was deficient, to say the least. The Minister has gone on record and said that the Data Protection Acts are sufficient. I beg to differ, and the amendments we table, if the amendments we table are not accepted, we may simply be recalling this lack of understanding, Tánaiste, of how data is used when there is an inevitable scandal in years to come. And I sincerely hope, I don't say that to be contentious or confrontational, Minister, I say that because I have a genuine, and our party has a very, very genuine concern that that could well be the case. There is not a law, the Minister maintains introducing an amendment that would prevent private operators engaging in monitoring on a for-profit basis would have an impact on how it is currently overseen by the prison service. There is not a law that says that the state cannot do this itself. There is absolutely no rule, Cathaoirleach, that says we must privatise and outsource everything. There are sometimes things that simply should not be outsourced, and I believe this is one of them. We will also table amendments to ensure that judges are given reasons in writing. This is not a lot to ask. It is not an onerous task for the courts to provide something that provides a record of decisions made in bail cases. It would be as much in the State's interest as in the defendant who is applying for bail. If we cannot have it in all cases, it should at least be available on the request of the defendant. A useful suggestion was made in the Dáil that in the absence of having a judge provide reasons for decisions in writing, then perhaps the audio recordings that currently happen in the courts could be automatically transcribed. This would probably be costly, but we must get to a place where we can identify whether there is consistency in bail applications and decisions or not. There are a number of other areas that were not dealt with adequately in the Dáil stages, and we will be tabling amendments to rectify these areas along the lines of discussions that happened in the Dáil Taoiseach. We are asking that the Minister would reflect on these issues and either accept our amendments at a later stage or indeed consider bringing forward amendments of her own.
Sinn Féin, Senator Black.